Who owns mine dumps in South Africa? At first glance, this may appear to be a straightforward property question. Hi everyone, and welcome back to SA Mining Desk. In today's episode, we examine how the law has developed, from early cases treating dumps as private movable property to more recent judgments. By the end of this video, you will understand why mine dumps are legally contested, how courts determine ownership, and when the MPRDA applies. We will proceed in 5 parts: historical legal framework from Minerals Act to MPRDA, core legal definitions that frame the debate, why disputes arise, key court judgments, consolidated legal position. Key takeaways. Let us begin. Background, from the Minerals Act to the MPRDA. Before the MPRDA came into effect in May 2004, mining in South Africa was governed by the Minerals Act of 1991. That transition marked a fundamental shift in how South African law understands mining waste in mineral ownership. Under the Minerals Act era, tailings were defined broadly as waste rock, residue, or slimes created during mining or mineral processing. Importantly, the holder of the mineral right automatically owned any minerals contained in those tailings. The MPRDA replaced this framework and introduced 2 new concepts: residue stockpiles and residue deposits. A residue stockpile refers to debris, discard, tailings, slimes, or waste rock derived from mining that is stored or accumulated for potential reuse. In simple terms, this is temporary waste, material set aside because it may be reprocessed later when technology improves or prices increase. A residue deposit, on the other hand, refers to residue stockpiles that remain at the termination of a mining operation or are permanently discarded in a designated area. This is permanent waste, material that has been abandoned with no intention of reuse. This distinction becomes critical as we move through the case law. Definitions that frame the entire debate. To properly understand mine dumps, we also need to consider 3 key concepts in the MPRDA prior and after the 2013 amendment: the definition of mining, the definition of minerals, and the concept of state custodianship. Originally, in 2004, the definition of mining focused on the physical act of winning minerals from the earth. After the 2013 amendments, that definition was expanded to include any operation or activity incidental to mining within the mining area. This represented a shift away from just the hole in the ground toward the entire mining ecosystem. Similarly, the definition of a mineral was broadened. While originally limited to substances occurring naturally through geological processes, the post-2013 amendments explicitly included minerals found in residue stockpiles and residue deposits. Finally, the MPRDA introduced the concept of state custodianship. Under common law, the landowner owned the minerals beneath the land. The MPRDA changed this. Mineral resources now belong to the people of South Africa, with the state acting as custodian on their behalf. This custodianship is exercised to achieve objectives such as equitable access, transformation, and socioeconomic development. Why mine dumps are so contentious? Although the MPRDA provides the legal framework, the reality on the ground is far more complex. Mine dumps are no longer viewed as mere waste. They are increasingly described as man-made ore bodies, often containing billions of rands worth of secondary minerals. They are economically valuable, technologically recoverable, and commercially traded. This creates competing claims between historic owners, new right holders, landowners, and the state. The core legal question is, are mine dumps movable private property or immovable property? To answer that question, the courts have stepped in and resolved it through accession law. Key court judgments. Konstanz Properties versus W.M. Spillhouse, which was decided by the Appellate Division on 22 March 1996. In this case, Konstanz Properties contracted a firm to install an irrigation system on their farm. The contractor bought components, pumps, pipes from W.M. Spillhouse, but went insolvent before paying for them. Spillhouse, as the owner of the components, wanted them back, but Konstanz argued they had acceded to the land and were now part of the farm property. The court had to decide when a movable asset legally became part of the immovable land, accession. The court applied the threefold test: the nature of the thing, the manner of its attachment, and the intention of the owner of the movable. The court held that while the first two factors are objective, the subjective intention of the owner is the decisive factor if the attachment is not so permanent that removal would cause substantial damage. The appeal was dismissed. Spillhouse remained the owner because there was no intention for the items to accede. This is the case Ataqua 2007 relied on in coming to a decision. Ataqua 2007. Decided by the Free State High Court on 13 December 2007, De Beers challenged the grant of a prospecting right over tailings dumps situated on subdivision 16 of the farm Jagersfontein 14. De Beers claimed ownership of the dumps and the minerals contained in them. The legal issue before the court was whether the tailings dumps were movable assets owned by De Beers and whether they fell outside the custodianship of the state under the MPRDA. To answer this, the court applied the modern approach to accession, relying on Konstanz properties. Accession determines whether a movable has become part of immovable land. The court applied the threefold test: the nature of the thing, the manner of its attachment, and, critically, the subjective intention of the owner. The court held that while the dumps were huge, they were distinct from the natural soil and could be moved or processed without permanently harming the land. Crucially, De Beers never intended to abandon the minerals; they were simply storing them for future treatment. Because of this, the court ruled the dumps were movables owned by De Beers. Crucially, the court found the MPRDA didn't apply here. It argued that once a mineral is severed from the earth and processed by humans, it is no longer naturally occurring. It is a man-made product. Therefore, it failed the legal test for a mineral under the original act. Furthermore, since these dumps were created long before 2004, they weren't created by an MPRDA holder, meaning they couldn't be residue stockpiles or deposits. The court essentially ruled there is no one-size-fits-all status for dumps. It depends on the specific facts of each case. The next case is Realeboga Bosaletsi and others versus Minister of Mineral Resources, decided on 26 September 2013. Here, applicants sought prospecting rights over the same Jagersfontein dumps. The department initially accepted their applications, but later refused them in January 2012, citing the Ataqua decision, which found that the MPRDA did not apply to the tailings dumps and that De Beers was the owner. This was a review application. The court found itself bound by the earlier Ataqua decision. Since the department, as the custodian, was a party to that decision and chose not to appeal it, the ruling that De Beers was the owner remained binding. As a result, the department lacked the power to grant prospecting rights over the dumps to anyone else.
We then move to Ekapa Minerals versus Lucky Sikui, decided on 13 January 2017 by Northern Cape High Court, Kimberley Division. Ekapa Minerals purchased the reprocessing business of Tailings Mineral Resources, TMRs, and related immovable properties from De Beers in November 2015, with ownership of the TMRs transferred in January 2016. A group of about 1,000 artisanal miners, ASM, claimed to mine the floors, thin layer of kimberlite remaining after De Beers removed the dumps, for a living. The ASMs admit the unlawfulness of their mining, but claim to be trying to regularize their operations. Ekapa sought an interdict against ASM to prevent them from entering its property in illegally conducting mining activities. To succeed, the applicants needed to prove 3 requirements for an interdict. 1. A clear right, in this case ownership and/or possession of the TMRs and properties. The central challenge to the clear right was the respondents' argument that the TMRs are minerals under the MPRDA and thus state property, making the sale to the first applicant invalid. 2. Prejudice and irreparable harm due to depletion of TMRs. 3. Absence of an adequate alternative remedy. The court granted the final interdict. The court held that the applicants satisfied all 3 requirements for an interdict. The court found that the TMRs do not fall under the definition of mineral in the MPRDA and therefore do not require a mining right for reprocessing, validating the applicant's claim to the TMRs. While acknowledging the legislative intent to close the Ataqua gap, the court held that the amendments did not automatically strip owners of movable private property. If a dump was created as a movable asset, it remained private property of the person who created it. In Darren James Smith v. Minister of Mineral Resources, decided by the Gauteng High Court Pretoria Division on 27 July 2021, in this case, Candero, third respondent, held a Section 161 permit under the repealed Mining Rights Act 1967 to treat tailings, the dump, on certain farms in Klerksdorp. Candero converted this permit to a new order mining right under the MPRDA, which lapsed in June 2010 after it was not renewed. The applicant, Darren James Smith, applied for a prospecting right for aggregates and gold ore over the property in July 2010, which was granted in July 2011. Candero appealed this grant, and the Director General, second respondent, upheld the appeal in December 2014 and June 2015. The applicant then lodged an appeal with the minister, first respondent. In September 2018, the minister upheld Candero's appeal and set aside the grant of the applicant's prospecting right. The core issue determined by the minister was the nature and ownership of the dumps, concluding they were movable and thus not regulated by the MPRDA, which rendered the grant of a prospecting right to the applicant invalid. The applicant brought this review application to set aside the minister's decision. The court dismissed the review application. The court implicitly accepted that the ultimate conclusion that the MPRDA does not apply to the dump, since it is movable property and not a residue stockpile created by a new order right holder, was a sufficient and correct basis to set aside the grant of the prospecting right to the applicant, regardless of the minister's specific finding on ownership. Even after the 2013 amendments, movable dumps could not qualify as residue stockpiles or deposits. Promispace CC versus DRD Gold Limited and others, decided by the High Court of South Africa, Gauteng Division, Pretoria, on September 26, 2024, introduced a different scenario. The application concerned a mine dump located on Farm Rotoport, portion number 125, farm number 237. The second respondent, City of Johannesburg, is the lawful owner of the property on which the dump is situated, having purchased it in 1985. The applicant, Promispace CC, sought a declaratory order that it is the lawful owner of the mine dump through appropriation, contending the dump was abandoned and therefore belonging to no one. The first respondent, DRD Gold, did not oppose the proceedings and filed a notice to abide. The COJ and the City of Johannesburg Property Company SOC Limited, JPC, opposed the application. The question here was not mining rights, but ownership through alleged abandonment. The main issue to be decided was whether the second respondent, COJ, is the lawful owner of the mine dump. The court concluded that the COJ is the owner of the mine dump. The court found that the dump had acceded to the land due to its size, permanence, and integration. The principle of ownership of land generally extends to what is situated on the land. It therefore belonged to the landowner, the City of Johannesburg, and could not be appropriated. This judgment reinforced that accession remains decisive and abandonment requires clear intention. The judgment established that a mine dump located on registered immovable property is generally presumed to be owned by the registered landowner if the landowner can demonstrate ownership or an intention to keep what is on the land.
Finally, we arrive at Mpilo and Zen Holdings versus Minister of Mineral Resources and Energy. The case was before the High Court Mpangala Division first decided in July 2023, where it dealt with an application for a final indict, and lastly, on May 5, 2025. Here, the court adopted a more purposive and contextual approach. It held that the dump had become immovable through accession, triggering state custodianship. In this case, the applicant Mpilo was granted a mining permit on January 25, 2023 for a property known as Farm Camelot 320 JU. Shortly after, the fifth respondent, Centurion, lodged an appeal against the permit. While that appeal was still pending, the regional manager, second respondent, issued a decision on May 9, 2023, declaring Centurion the owner of the mining tailings, dumps on the property. Based on this declaration, the Department of Agriculture, Land Reform, and Rural Development, third and fourth respondents, granted Centurion access to the property in June 2023 to remove the tailings. An urgent interdict had previously been granted in July 2023 to halt these operations. In granting the interdict, the court found that if the material contains gold or minerals the state is mandated to manage, it qualifies as a mineral under the MPRDA. The court also treated the dump as a residue deposit since the original mining had ceased. Crucially, the court rejected the idea that all historic dumps are automatically movables. The court also confirmed that winning minerals from a residue deposit constitutes mining. In 2025, the court further clarified that the regional manager was not empowered by the MPRDA to make ownership declarations over tailings. Ownership disputes are judicial matters, not administrative. This decision was reviewed and set aside, along with that giving Centurion access to the property to process the dump. We did an analysis of this case. If you would like to know more, the link to the video is in the description.
Consolidated position and key takeaways. So what does all this mean for the sector? First, it is important to note that the law of accession was laid down by the Appellate Division, the Supreme Court of Appeal, in 1996 and applied by the different High Court divisions, Gauteng, Free State, Northern Cape, and Mpumalanga, to name a few, as it applies and relates to mine dumps within the context of the MPRDA. The different divisions, applying the same principles, arrived at different conclusions. While some divisions have decided similarly dumps are movable private property, there are those who have held that they are immovable property having acceded to the land. When dealing with mine dumps, the following question must be answered. Is the dump movable or immovable? And to determine this, the threefold test comes to play. Whether the mineral found in the dump constitutes a mineral as defined in the MPRDA, whether the act of winning such a mineral from the dump constitute an act of mining as defined in the MPRDA, whether the mine dump falls under the definition of either residue deposit or stockpile. The final determination will therefore decide whether a dump is movable private property or immovable, which will then attract the application of the MPRDA. In earlier cases, like Ataqua and Smith, in using the threefold test of accession, the subjective intention of the owner was the determining factor. If the material was kept for future retreatment, the dump was movable. However, recent cases have shifted toward an objective test. In Promispace and Mpilo, the courts found that massive size and permanent integration into the earth make a dump immovable. On the question whether the dump is a residue stockpile or deposit, early cases excluded historic dumps. The 2013 amendments explicitly include waste from old order rights. In Mpilo and Zen, the court adopted a purposive approach, ruling that the law now captures these historic deposits and that processing them constitutes mining under the Act. Last questions relate to minerals and mining. The definition of mining in the 2013 amended is broadened to include residue deposits and stockpiles. Similarly, the definition of mining includes the entire mining ecosystem. In earlier cases, like Ataqua and Ekapa, mineral found on dumps were held not to constitute a mineral since they have been severed from the land and not naturally occurring.
with recent judgment, Mpilo and Zen confirming that winning of minerals from a residue deposit constitutes mining as defined in the MPRDA, and that in view of minerals, the court focused on the content of the dump rather than its geological origin. If it has mineral value, it falls under the Act. Key takeaways. Determination of ownership is a judicial matter. The department cannot decide on ownership of dumps. Doing so is ultra-virus. No one-size-fits-all. Each case must be assessed on its own specific facts and merits. The threefold test, nature, attachment, and intention, are the tools used to determine if a dump is movable or immovable. Compliance is still required, even if the MPRDA doesn't have jurisdiction over a movable dump. Other regulatory regimes, such as NEMA and water legislation, may be applicable. The MPRDA is currently being amended to further address these gaps regarding mine dumps. In summary, not all dumps are automatically movable. Each case must be decided on its own facts and merits. That brings us to the end of today's video. Thank you for joining the SA Mining Desk, where mining law is clarified and simplified that we may all participate in the exploration of our common heritage, mineral resources. If you found this video useful, please like, comment, and subscribe to the channel. Until next time, take care.